Good afternoon, courtroom two. Are we ready to begin?
Yes, we can go ahead and start. Thank you.
Good afternoon. Good afternoon, gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we're offering you the assistance of a public defender to assist you this afternoon if you choose to utilize their services. Who do we have first?
This is position number 1, Bailey.
Good afternoon, Mr. Bailey. You have been charged in case 24 CR 007053E with hit and run. Is there a history?
7 total. Resident of New Orleans. 2011 criminal damage, domestic arrest. Jail was a recommendation.
Good afternoon.
Good afternoon, Judge. This incident occurred back in June around 4:15 in the morning. Officers were dispatched to an auto accident at 2097 Metropolitan Parkway. The victim in this case is Amelia James. She advised that she was in her vehicle and was struck in the back by a black sedan with the tag number that she wrote down. The driver drove off. The officers checked the tag readers in the area and found a tag that matched the vehicle description provided by the victim. The victim also identified the driver through a photo lineup, and the physical description she gave of the driver matched his license photo. And Your Honor, given that he's an out-of-state resident, we would argue that there's no ties to the community here, so we would ask for 1,000 surety, no contact, no weapons, drugs, or alcohol. Thank you.
Afternoon, Mr. Cook. Is this your case?
Yes, Your Honor. My client is 43 years old. He actually lives at 1991 Delow Drive, Atlanta, apartment V3. I believe that New Orleans address is out of date. He can verify that again if he would like. He's 43. I don't think he's had, unless I missed it, another arrest or no arrest of any consequence. His position here is that he did tap a car in the McDonald's parking lot. They did exchange information that was in part how, and that the other party actually got in touch with an insurance company. I realize it's more of an obligation with a hit and run than after an accident than that. But not as far as we can tell. We would be seeking a signature bond through the jail.
Your Honor, if he lives here, then we have no objection to signature bond.
Okay. It'll be a $2,000 signature bond through the jail. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Bailey.
Position 2.
Good afternoon, Mr. Boyd. You've been charged in case 24 CR 00 criminal trespass and damage to property. Is there a history, Mr. Howard?
2017 possession of drug-related objects. Same thing for 2016, 2014 simple assault.
Yes,
Your Honor, this incident took place on the 14th at 1890 House Apartments, which is located at 1890 Myrtle Drive. 3 days ago, the defendant was evicted. While the marshals were on scene executing the eviction, the defendant was told he cannot return to his former residence. Complex employees returning to the location, he kicked in the door to his former residence and removed several items that appear to have been his from the eviction. Your Honor, he has history, but it's older, so we're requesting an SOB, stay away, no weapons, drugs, or alcohol.
Mr. Cook?
No objection, Your Honor.
All right. For each charge, it'll be a $1,000 signature bond through the jail. Makes for a total of a $2,000 signature bond through the jail. Stay out on bond. Good luck to you, Mr. Boyd.
Number 3.
Good afternoon, Mr. Garcia. Good afternoon, sir. You've been charged in case 24 CR 00.
This was position number 4.
Okay, thank you. This is Mr. Gibson. Good afternoon, Mr. Gibson. You have been charged in case 24 CR 007059Y with battery family violence. Is there a history, Mr. Howard?
2023 FTA. Got an open simple battery theft by taking a state court. 2016 probation, had an ag assault from 2016. It was dismissed. 2014 criminal line, but that criminal attempt was a conviction. And he had a 2013 arrest related to a CWAC charge.
Thank you. Desiana?
For the one in state court, do you have it?
They got 20 CR 004457Y.
Oh, okay, I got it. Thank you. Your Honor, this incident took place on St. Patrick's Day this year, Park Place. The victim in this case is Jasmine Anies. She states that she and the defendant over whether or not to terminate the pregnancy. The defendant was apparently very persistent about it. She had agreed to do it, but didn't tell him when she was going to do it. Apparently she had the procedure and didn't tell the defendant. There was an argument over whether or not she's going to have the procedure after the procedure had already taken place. She was using the restroom and he came into the bathroom, pulled her hair, struck her, and threw her on the floor. The victim had visible bruising to her left cheek and shoulder. We've been in touch with her today. And they have no children together. She states the incident location was her residence, but she no longer resides there. She states that the defendant also choked her. However, she didn't feel like she was going to pass out. She and the defendant have met up since this incident and were trying to talk things out, but apparently it didn't go very well. And the defendant got upset and busted out her windshield. She did not report this incident to the police because the defendant threatened to have her contact with her in the last week. However, she's not responded. And she, at this point, is in fear of him and would like no contact. Your Honor, he does have the open case. It's involving a different victim. The state's requesting a $2,500 surety bond, no contact, a stay away from the victim's residence, wherever that may be, no weapons, drugs, or alcohol. And if you could sound for Miss Jasmine Anies.
What is the last name again, Ms. Tessiano?
Anies, Eneas.
If Ms. Anies is on the line and wishes to address the court, now is your opportunity to do so. Do you know what the bond was in the other case, Ms. Tessiano? Was it a good bond?
Yes, let me check. It was from March 23rd that just says defendant made new bond, but there's no order. I can look on the booking screen and see if there's any information.
While you do that, Mr. Cook.
Your Honor, my client is 29 years old, works in a grading for a grading company and also at racetrack on the weekends, makes a modest living. He denies this completely. He certainly does know Ms. Anies. They lived in at one point. Neither of them live there now. He's now married and lives in Southwest Atlanta. He denies absolutely in the warrant.
All right, it looks like he posted a $6,000 surety bond. This case may have been a bind over. And by this case, I mean the 20 CR case, not the case before you. And he posted that in 2019.
For this case, it'll be a $3,000 signature bond through pretrial level 2. No further contact, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Gibson.
That's perfect.
Okay.
APD.
Good afternoon, Judge Morrow. This is going to be position number 6, Ms. Hunter.
Position. Good afternoon. Good afternoon, Ms. Hunter. You've been charged in case 20 with interference with custody, 2 counts. Is there a history,
Fifth
Mr.
arrest.
Howard?
Got open ag assault battery DB. 24 SC 003. 2023 probation violation. 2021 battery DB. Cruelty to children.
Yeah.
Your Honor, this incident took place, it began on August 17th of 2024. Officers responded to 50 Clay Street, apartment H5 in Fairburn regarding 2 missing children. The children are identical. The defendant is their mother. The incident location is the father's address. The caller, whose name is Tanika Wilson, at the time of this incident, the children were supposed to be home. She reported to police that she woke up earlier that morning between 6:30 and 7, checked on the kids, told them to do some chores, went back to sleep, woke up at 10 a.m. and the kids were gone. She called dad, looked around the apartment complex, got in touch with dad, who had at some point gotten in touch with mom. And she told him that she had the boys and she would return them the following day. The officers spoke with the defendant, told them that she told them that she went to dad's house around 6:30 that morning and got the kids. They were fine. She gave the officers an address of where they were going. The address was her mother's house. She told the officers she's been living out of a hotel and on the officers. She also mentioned something about having her kids write letters about dad because she doesn't think that he should have custody. And basically, a order from dad, it showed that mom was supposed to have custody every first, third, and fifth Saturday from 10 a.m. to 4 p.m. The incident date was the 17th. It was the third Saturday day. And mom said she was going to return the kids the next day, which even though she was supposed to return them earlier, return the kids, dad calls the police. The police try to contact the defendant. She doesn't answer. And at that point, the warrant's issued for her arrest. A couple days go by, off answer, another report's made. Throughout this process, the police also went to the hotel where the defendant told the officers she was living. And it was the hotel staff who advised that she had checked out back in June, way before this incident. They went to the other address that was provided, which was the defendant's mother's house. No one answered the door. The officers spoke with the neighbor before this incident. Dad made another report a couple days later. The children have still not been returned. At this point, he has no idea. Thankfully, at some point, Dad was able to get in touch with the kids through the third parties periodically to make sure that they were okay. However, Dad actually didn't get the kids back until 3 days ago, Judge. So they were gone without anyone knowing where they were, and they were not in school from August 17th until October 12th. And the only reason that the children were found was because the defendant finally took them to their football practice where Dad was, and about the police. On top of all of that, Your Honor, Dad is a victim in 2 other cases of the defendants, the 2 counts of cruelty to children in the 3rd degree for striking Dad in front of the kids. She also has that open felony pretrial mention for aggravated assault, stabbing him in the leg and striking him in the face. That case was indicted in July of this year. She's out on a $10,000 surety bond. And she's been out on bond since roughly November 2022. Her bond orders no contact with Dad. She's been out on, the order does note that all visitation has to be done through third parties. She's also ordered to stay away from his residence, where she showed up at 6:30 and took the children. She failed to appear at her arraignment in that case on September 4th because you can't come to court when you're absconding with your kids. And by the way, the jail, I'm not seeing a bench warrant or anything for that. And I'm not seeing a hold on her booking screen if you want to look into that. We've been in touch with Dad today. His name is DeAndre Roebuck. He states that basically she's had very limited visitation, and at the incident date, she came and took the kids without him knowing, didn't bring them back until October with football practice. He obviously wants no contact and wants her to stay away from his residence in accordance with her other bond orders. Your Honor, the defendant before you, it's very concerning to me. She doesn't care about court orders. She's in violation of her felony bond. She's in contempt of her parenting plan. She was out on bond on the first battery case when she stabbed the same victim in the leg and was ordered to have no contact in that bond order. She pled to her first battery and then had a probation violation because she refused to take the parenting class and FFIB and failed to come to court. She clearly doesn't see the importance in keeping her children in school, cooperating with law enforcement. I mean, I have zero faith that she's going to follow any condition that you put upon her. She's a danger to these children because of the actions in this case, obviously, but also she had very limited visitation to begin with, 7 hours biweekly. There's a reason for that. Clearly, a judge found that it was not in the children's best interest for her to be the full-time custodian to turn over children. She apparently doesn't have a stable address. To the extent that the defense may argue that this is a civil matter and that she wants more time with her kids, there are plenty of civil remedies available to her through family court that do not include what I would characterize as a risk of reoffense as well. She did not give these children back willingly. The police had to get involved, even when she finally did bring them to practice a month and a half later. We have nearly every AL factor here, Your Honor. She's also a flight risk. She absconded for a month and a half and no one knew where she was. We found out from the victim late this morning that the children were not returned until 3 days ago. The warrants don't state that. So frankly, I'm not sure that this is a misdemeanor anymore. We will certainly look into any other upgrades that are possible. But at this point, Your Honor, we're asking for a cash bond in whatever amount the court deems appropriate, no contact with DeAndre Roebuck in accordance with her felony bond, no physical visitation of these children until further order of the court. We're also asking for an ankle monitor to be paid for by the defendant so we can make sure that she's not near Dad's address. And if, God forbid, she does take the children again, we're also asking for a mental health evaluation and no weapons, drugs, or alcohol. And if Your Honor can sound for Mr. Roebuck.
Mr. Roebuck, I see you on the line. If you would like to address the court, now is your opportunity to do so. You, of course, don't have to, but if you would like to, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. Okay. Does not appear that he wishes to address the court at this time. Mr. Cook, is
No,
this your
Your Honor,
case?
it's my case. Good afternoon.
Oh, good afternoon.
My
Mr.
client is
Cloud.
32 years old, Your Honor. She tells me that the parting these 2 young boys, my client is currently in a financial bind. Of course, a cash bond would simply mean that she would be sitting in jail. In fact, she tells me she's not in a position to even post a surety bond. This is into consideration in setting this bond. She alleges that the boys are being abused, and that was a huge part of her concern with regard to them, and that they have been contacting her because they want that they have endured from their father's hands. Of course, these are all allegations, but Attorney DeCiano is quite correct in that I would certainly argue that this is a civil matter and would more appropriately be dealt with in family court. But I would ask the court to consider giving my client a signature bond so she can get out of jail. Otherwise, she's just going to be sitting there. We are okay with the conditions of no further contact with the alleged victim. Nothing further on.
Okay, so for each of the counts, it'll be a $1,000 good bond, makes for a total of a $2,000 good bond. No further contact with Deandra Roebuck at this time. No further contact with the minor children. If there is some type of custody agreement that the Superior Court issues at a later time, this part of the order can be modified. But they're going to have to go to Superior Court as far as the arrangements with custody go. But until they do that, there will be no further contact, no drugs, alcohol, weapons while out on bond.
Thank you.
Good luck to you, Ms. Hunter.
Thank you, Judge Morrow.
And Your Honor, that concludes my business before the court today. May I be excused?
Yes, have a good afternoon. Thank you, Ms. McLeod. And Francois, is that it for ACDC today?
Yes, it is. Thank you, Judge.
All right, thank you. I'll see you next time.
Okay, thanks.
Courtroom 2, who do we have next?
We can go to 3 South, to position number 9.
Okay, thank you. This is Mr. McMahon. You're charged in case 24 CR 007064E with criminal trespass and damage to property. Is there a history, Mr. Howard?
14. Last arrest was this year for vehicle theft. 2009 criminal attempt to commit a felony conviction. That's all.
Good afternoon, Ms. Hunter.
Good afternoon, Your Honor. This did occur on October 14th. Officers responded to 217th Street in the city of Atlanta, which is the Microsoft Center. They were there because employees of the center called police when they saw an unknown man in the kitchen of the building holding 2 knives. Officers approached him and were able to get him to surrender the weapons. He told officers that he'd been smoking meth in the kitchen for several hours and that people were following him. So he took the knives to protect himself. Your Honor, the state is recommending a $1,000 surety bond to stay away from the Microsoft Center located at 217th Street and drug and alcohol evaluation and no drugs, alcohol, or weapons while out on bond.
Did they take him directly from the Microsoft Center to jail, or did he have to go to the hospital beforehand?
I did not see any notices that he went to the hospital, Your Honor.
Okay, thank you. Mr. McLean? Yes, Mr.
Yeah.
McLean?
Yes, Your Honor. That bout of paranoia about thinking people were following him, it wasn't that he was having hallucinations. So as long as things are kind of normal, he might not need a BHET, but one could be advisable as well. Your Honor, my client is 50 years old. He has the prior thing in Georgia. He's been in Georgia about 10 years. He grew up in Miami, and he has a very good mailing address to monitor with a relative in Miami, but he's living now at the Gateway Center at 275 Prior. He's here for now and can follow his mail. If the mail is sent to the Gateway Center, they don't really have a mail drop like several shelters do. So he would be actually residing at Gateway and really checking his mail at his relatives at this Miami address, which is solid. So if the court were to consider a signature bond, I would note that he's supposed to work at UPS, and he's got a start date on a job coming up, and he's got to get his act together to show up to that and get that good UPS job and get going. He does have a matter in Colorado that is open, but does not believe it's going to be an extradition. He'll just watch his mail on that.
Okay. It's going to be a $2,000 signature bond through pretrial level 2. Stay away from the Microsoft Center, BHET, and no drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Position 7.
Good afternoon, Mr. Judon. You have been charged in case 24 CR 007062C with criminal trespass, fare evasion, simple battery against a police officer, and willful obstruction of law enforcement. Their history, Mr. Howard.
No.
Ms. Desiano.
Your Honor, this incident took place on October 13th, 2024. Officers were flagged down at the Midtown MARTA station. The defendant entered the fare gates without payment. He was advised to leave the station several times. He refused. He was asked to place his hands behind his back, and he resisted and then took a fighting stance. And after several attempts to gain control, while he was on the ground, he struck the officer in the head 3 times with a closed fist. Simple battery against law enforcement and a signature bond in the remaining counts. No weapons, drugs, or alcohol, and a stay away. Thank you.
Mr. McLean.
My case, Your Honor. Your Honor, my client is 18 years old. He works as kind of a freelance handyman. I believe the pretrial reported no arrest. We would be seeking a signature bond, but it might, I don't know, may be restricted given the battery on the police officer and the obstruction. But if possible, a signature bond at whatever level the court deems appropriate. If not, then the lowest of possible surety bond.
Where does he live, and does he have will he have does he have someone that can co-sign?
Well, that may be an issue. He does live with a friend at 247 Twin Hill Road, Austell. He tells me he has no parents in town, some relatives in Alabama, so he was not able, because they asked specifically with that in mind, about a possible co-signer. He was not able to provide a name at the time I spoke with him.
Okay, well, if he can provide a co-signer, I will give him a signature bond. If he cannot provide a co-signer, then I'm going to give him a good bond. So, if he can't,
He has a name.
He does.
Gabriel Judon, Senior.
Who's that?
Gabriel Judon, Senior.
and who is he to you?
That's my dad.
Good afternoon, Judge. I'm online.
Oh, okay. Good afternoon, sir. Can you activate your camera for me?
I'm sorry?
Can you activate your camera for me?
Absolutely.
Thank you. Yes, yes, sir. Can you spell your name for me also?
Judon, Judon. First name, Deveren, Deveren.
Thank you for being here this afternoon, sir. If you can raise your right hand for me. Do you swear from testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. So you are willing to sign for your son to get him out of custody, is that correct?
That is correct.
Okay, where does he live? Your son?
With a friend in Austell.
Okay, and does he plan on living there once he is released from custody?
As far as I'm aware, yes.
Okay, and what else would you like to tell me about him?
I would like to say that if the court deems it necessary for him to come back to my house because I live about 30 minutes from Austell, then that would be a possibility. I would also like to say that if possible, I'd like the case dismissed in order to preserve his future. He just signed up for the Air Force, and I'm a combat vet myself with the Marine Corps. And the decision that he made could possibly mess up his chances of continuing to go to the Air Force.
Okay, this is only a bond hearing this afternoon, Mr. Judon, so you all can continue to discuss that with the solicitor's office. Once this bond issue is resolved today, So he's completed high school? Is
Yes,
he working?
not at the moment.
Not at the moment.
I would like to ask the court to release him on his own recognizances with time served without a bond because he's been in jail for about 3 days now.
I haven't heard a Riverside issue, Mr. Cook,
I
so,
didn't see a Riverside issue, Your Honor.
okay.
The
All
right.
Riverside only, we throw it around a lot. Riverside only applies if it's a warrantless arrest to begin with. And then it's 48 hours, not 72. But I don't see a Riverside issue.
And who are the Gilberts that are on with us?
I'm his mother, and this is his stepfather. So we're his family that he's referring to in Alabama. He was just actually, what is it, last month, he's sworn into the Air Force, and he's basically waiting to go to boot camp.
Waiting on a job.
So they're going to assign a position for him in the Air Force, and that's all he's waiting for to go on the boot camp. So provided that you know, I'm really hoping that this doesn't ruin his future.
Okay, I understand your concern. Well, let me see. At the present time, and thank you all for being here also. Mr. Janelle, you're going to have to come and sign him out. I'm going to let him release him on a signature bond through the pretrial services. And if you will stay in touch with Mr. Cook, are you going to continue to represent him?
Your Honor,
after
they have to
today?
reapply after we represent them at the hearing.
Okay, well, given that he is apparently unemployed, I would imagine that he would qualify for your services.
Yes, probably.
Unless his family chooses to get him private counsel, but I would ask you, Mr. Cook, if he does qualify, for you to stay in touch with the family and with the solicitor's office, provide them with all the information regarding this young man and where he's headed, and see if you all can possibly work something out. But as far as today goes, for the criminal trespass, it will be a $500 signature bond through pretrial level 1. For the fair evasion, it will be a $500 signature bond through pretrial level 1. For the simple battery against the level 1, for the willful obstruction, it'll be a $1,000 signature bond through pretrial level 1. He is to be released to his father, Devron, like him staying in your household, Mr. Judon, as opposed to where he's staying at the present time, and no drugs, alcohol, or weapons while out on bond. If you wouldn't mind putting your address on my order.
Absolutely.
Hey,
Can you do that for the court?
Yes.
Okay. You all have any
Oh,
questions
thank you,
regarding
Your
that?
Honor.
hey,
Yeah.
Cook, you have the cosign link, right?
I believe I do. Yes. The jail normally provides that when they but I can send it as well.
Good luck to all of you all.
Position.
Good afternoon, Mr. Lewis. You've been charged in case 24 CR 007065C with 2 misdemeanor offenses. Their history,
What's
Mr.
the
Howard? Lewis.
Third arrest.
Darius.
You got to open theft by taking in state court. Open reckless conduct. The theft by taking 24 CR 003 726 3742C. That's it.
Okay. Yes, Ms. Hooter.
Thank you, Your Honor. Your Honor, this incident did stem from photographs that were sent by the defendant on 12/20 of 2023. They were reported by the victim, Ms. Londa Adams, when she went to the police station to report that Mr. Lewis, who is the father of her child, the pictures that are the basis of these accusations were sent to her other child's father, Mr. DeVorce Wilson, back on 12/20. He divorced the following phrase, just sending to everybody my phone and social media so it can get screenshotted and everybody got it. On that same day, he also sent to DeVorce's cousin, Mr. Mondrick, similar photographs on Facebook Instant Messenger on the defendant about sending the photographs. The defendant stated that open case ending in 3742C. Ms. Londa Adams is the victim in that case. And there is a no contact order with Ms. Londa Adams in that case. It's a $5,000 surety bond. However, despite the fact that there is a no contact order, Ms. Adams, who is on the line, has reported to our office that he continues to harass her via social media and telephone. For that reason, Your Honor, the state is recommending a $7,000 surety bond, $3,500 on each count, no further contact with Ms. Londa Adams, her family members, including their shared child, and that would include direct or indirect and on social media, Your Honor. And I would just ask that you sound for Ms. Adams.
And do you
at the
know
appropriate time.
that bond order, the previous one with no contact, 5,000 good, if I issued that bond or
I
not?
think it's Judge Mincy's signature.
Okay, thank you. Ms. Londa Adams, I see that you're on the line. If you would like to address the court, although you don't have to, but if you would like to, now's your opportunity to do so. I need for you to activate your camera, unmute yourself, and I'll have to swear you in.
Good afternoon.
Yes, ma'am. Good afternoon. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the
Yes.
truth? Okay, you can place your hand down. What would you like
So
to tell
pretty
the
much
court?
Darius Lewis has been harassing and stalking and vandalizing property for almost going on 3 years. Essentially, it started out because he was upset that he wasn't able to see his son or picking his son up for that time period. However, he still continued to stalk and harass, mainly through social media, sending new photos of me to my oldest son's father, his cousin, my father, and other people who are on social media. Other than that, in addition to that, he's also made threats via voicemail on my mom's cell phone that he's going to kill me. When he sees me, he can't wait to see me, and I can run by vehicles. But those, I have filed reports onto those vehicles, but the most recent one, the situation occurred back in, I believe, June sometime, where he keyed my car. I did not file a police report on that because that was also the last time he was able to see his son because of that event. And that led me to still continue to contact my relatives, mainly my sister and my brother on social media, where he pretty much created a fake profile picture of my other people of the family on social media. And leaving comments basically stating that when he sees me, he can't wait to see me, and I can run, but I can't hide. So this has been going on for over 2.5, 3 years. It's been very stressful. Has done so much to my, pretty much to my confidence, to the point to where it's like really hard to see people and family, go and speak to friends just because of the new photographs that he has sent to so many people that I'm very, very close with. So yeah, it's been a lot. It's been a lot. And I don't understand why, because he was able to see his son despite all of the things that he have done. He has been able to still be in contact with him and also be able to see him whenever he was able to. And also he showed up to my house, the house that I previously stayed in, and he was upset because he arrived uninvited, and I advised him if he wanted to see his son, all he had to do was call me. But he got upset and he pulled out a weapon and he let off a shot in front of the door, in front of the kids who were also sitting presently at the door at the time. So yeah.
Okay. Thank you, Ms. Adams. I appreciate you being here. And Ms. Hood, that what she's just describing, that is the reckless, that's the open case?
That is, Your Honor.
Okay, thank you.
Your
Yes,
Honor,
Mr. McClain.
my client has a high school equivalent. He has been working for Amazon. He's driven their vehicles and contractors' vehicles. He also does lawn care with his cousin. He has been in Georgia since 2001, so that's 23 years, and he's only 32. So basically, all his adult life and part of his childhood, he grew up here. He's local. Your Honor, he would like to point out that the two case numbers, the two that end in 3726C and 3742C, is basically one case, and he was told that administratively it was recognized as a mistake to call them two cases instead of one. So he would like to be thought of as having one prior instead of arrest rather than two. I believe the PSA, the public safety assessment, noted that he has no FTAs and he has no convictions. He has no prior violent convictions, of course, since he has no convictions at all. He would like the court to grant him a signature bond and trust him to follow the directions of the court and stay away, have no contact, and show up in court on time.
Okay. What was the date of the alleged reckless?
I believe it was February of 2024, February 26th of 2024. I can double.
I'm just trying to put these in order because these alleged charges are from December of last year.
I do
So-
remember when I was reviewing it, this happened and then the shooting happened and then the investigation into the pictures happened sometime later,
Okay.
which would have been August of this year. Okay, it was February of 2023, Your Honor.
Okay.
So February 26th of 2023, he was arrested for the reckless conduct. And we filed it on June of 2024. Okay.
When was the bond issued?
So
For the
give
reckless?
me one. The bond was issued June 13th of 2024.
All right, so for these two misdemeanors, given that this allegedly happened before he was issued the bond in the theft by taking reckless case, it'll be a $2,500 signature bond through pretrial level 2, makes for a total of a $5,000 signature bond through pretrial level 2. No further contact with Ms. Adams or her family members. No drugs, alcohol, weapons while out on bond. Mr. Lewis, let me make it clear to you what no contact means. It means absolutely no email contact, no social media contact, no internet contact, no contact whatsoever with either Ms. Adams or her family members. If you do have contact, okay, good luck to you, sir.
This project.
It says level 2 on the little sheet that you sent to
Yeah.
me.
Yeah, I don't know why they do it like that, but yeah.
Okay. I'm only going by what you're telling me.
They got open cases.
Okay.
Well, no, it wasn't me.
I mean, it's pre-trial,
Yeah,
right?
but if something pop
All right.
off, they ain't coming looking at me. I don't want the news looking at me for nothing.
All right, thank you.
I'm putting people under the bus.
Who do we have next?
Position 5.
Mr. Harris, good afternoon. You have been charged in case 24 CR 007060G with willful obstruction of a law enforcement officer, possession of marijuana less than an ounce, and wearing a mask, hood, or device which concealed your
Ninth
identity.
arrest last was in
Is your
September.
history?
You got to open possession of a Schedule 1 or 2 with intent, possession of marijuana, possession of drug-related objects, possession of a knife or a firearm during a commission. 7/7/2017. It says a weapon, firearm on premise of nuclear power plant or facility. Conviction. That's it.
Thank you. Stesiana?
Your Honor, this incident took place on the 14th. Officers were completing a traffic stop on Joseph E. Boone Boulevard when they observed the defendant wearing a ski mask on a scooter riding in the middle of the road. As the defendant rode past, he looked at the officers and said, "Get out of my way, bitch." Approached the defendant. He began taking several things out of his pockets. The officer asked him who he was calling a bitch. The defendant said he was talking to someone else. The officers noticed a strong odor of marijuana. The officer asked if he had any drugs on his person. The defendant at that point said recovered a scale, about $500 of cash and 7.4 grams of marijuana. The defendant was placed under arrest and at that point resisted. Your Honor, we're asking for a $500 surety bond for each count for a total of $1,500. No weapons, drugs, or alcohol out of bond.
Whose case is this?
Mine, Keith Cook. Your Honor, my client is 28 years old. He is working currently for DHL at a warehouse in Union City, makes a very modest income. It's not full-time. He has 2 kids. We understand the obstruction might be restrictive, but we would be seeking a signature bond at whatever level the court deems appropriate, if possible.
All right, it's going to be a $250 good bond per charge, makes for a total of a $750 good bond. Good luck to you, Mr. Harris.
Thank you.
Number 11.
Good afternoon, Mr. Ramsey. You have been charged in case 24 CR 007058F with criminal trespass.
I got first.
Your history, Mr. Howard?
I do as well, Your Honor.
Ms.
This
Huda?
did occur on October 14th of 2024. Officers from Sandy Springs were called to 8185 Colquitt Road, apartment F. They learned that the defendant was in a dispute with his roommate, Mr. Daniel Jackson. This was belonged to the defendant that had gone missing. In an attempt to find it, he knocked on Mr. Jackson's door repeatedly, but the victim didn't answer. So after a few minutes, the defendant came back, used an unknown object to unlock the door. As soon as he opened the door, the victim, Mr. Jackson, pointed a handgun at him because he was concerned for his safety. The incident was captured on cell phone video by Mr. Jackson's girlfriend, Ms. Sakani Watson. The two men continued to argue until the police arrived. Your Honor, we are asking for a one, Mr. Jackson, and a stay away from 8185 Colquitt Road, which we do understand he lives at, but because this incident was so recent and tempers flared so much that a handgun was brandished, we think that a stay away was in this morning, but we would still ask for you to sound for him at the appropriate time.
Daniel Jackson is on the line and wishes to address the court. Now is your opportunity to do so. Doesn't appear so.
Your
Mr.
Honor,
McLean?
no objection to the signature bond.
Anything else?
That's basically it. He will stay away. I thought the last paragraph of the police report was shocking to me, that they were filming themselves waiting for a door to be opened with a gun trained.
Okay. It'll be $1,000 signature bond through the jail. No further contact with Daniel Jackson. Stay away from the Colquitt Road address. He can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Ramsey. He has a question for you, Mr. McLean.
So 8185 Colquitt Road is actually my apartment. My name is on the lease. They temporarily, and they overextended that stay. This is the second incident. The first incident, this is the second incident in which literally I felt threatened. I was looking to retrieve my table, knocked on that door several times.
Mr. Ramsey, you have a right to remain silent. Anything you say can be used against you. Okay, I don't want to explain. So, if Mr. Ramsey is still living at that, I'm sorry, if Mr. Jackson is still living at that Colquitt Road address, you'll somehow have to have him. If he ceases to live there, then you of course can go back there. But as long as he's there, and you cannot have any contact with him once you get out of custody, because you're in violation of my enforcement, back to that apartment, and he's no longer there, then I will allow you to stay there, but not while he's there, okay? And you can work with Mr. McLean or whomever as you go forward with the criminal trespass charge. All
What
right.
exactly is the is the
Good luck to
signature bond? Okay. Thank you.
Good afternoon, Mr. Thornton. You've been charged in case 24 CR 007054F with battery and criminal trespass and damage to property. So your history, Mr. Howard?
11, 2020 FTA, 2017 battery DV conviction, or 04 Accusations.
Yes, Ms. Huda, is this your case?
It is, Your Honor. This incident did occur on October 13th of 2024. Officers from East Point were called to 1875 Vesta Avenue. There they made contact with Miss Yorkidra Jordan, Yorkedra. Ms. Jordan, the verbal fight escalated to the defendant, Mr. Thornton, striking her on the left side of her face with a closed fist, causing swelling that was observed by the officer. The victim then picked up a bag of garbage on top of Miss Jordan's vehicle and then snatched the chair out of her hands and threw it at the windshield of her vehicle, causing the glass to break. The locus of the incident is his house and she does not live there, Your Honor. The state is requesting $2,000 on each count, no further contact with Ms. Jordan, and no drugs, alcohol, or weapons while out on bond. We would ask that you sound for the victim at the appropriate.
Ms. Jordan is on the line, wishes to address the court. Now is your opportunity to do so. It doesn't appear so. Mr. McLean?
Your Honor, my client is 46 years old. He does live there. She's not. is disabled and has applied for disability compensation to do some home improvement work. So he is struggling financially. He does own his own truck and has some tools to facilitate that activity. But he would like the court to consider a signature bond, Your Honor, because there's no reason for him to miss court. He's got the stable address. There's no reason for them to be in contact with each other or have any further problems.
Okay, for the battery, it'll be a $2,500 signature bond through pretrial level 2. For the criminal trespass, a $500 signature bond through pretrial level 2 makes for a total of a $3,000 signature bond through pretrial level 2. No further contact with Ms. Jordan. No drugs, alcohol, weapons while out on bond. Good
Number
luck to you, Mr.
13.
Thornton. Good afternoon, Mr. Winfrey. You have been charged in case 24 CR 007055H with battery family violence.
13.
Your history,
Last was
Mr. Howard?
2019 abandonment of drugs conviction.
Yes, Ms. Widow.
Thank you, Your Honor. This did occur on August 11th of 2024. Officers were called to 3718 MLK Drive, apartment 3111. When they arrived there, they spoke to Ms. Tiffany Johnson, who said that the became physical. During that altercation, he purposely stepped on her foot, causing her to shove him off her. Then she ripped out some of her braids. The officers did document where hair was missing on her head. There were no marks to the neck area, Your Honor. The state is asking no further violent contact with Ms. Tiffany Johnson. I believe she is on the Zoom call. The no further violent contact is at her request, and I do believe AOA, but I would ask that you sound for Ms. Johnson.
Ms. Johnson, I see you there. If you would like to address the court, this is your opportunity to do so. I would need for you to unmute yourself, activate your camera, and I'll have to swear you in if you choose to address the court. Doesn't appear that she wishes to address the court this afternoon. Okay. I'll hold on for you, Ms. Johnson. While she's getting that together, Mr. McLean.
Yes, Your Honor. This did take place back in August the 11th, and he turned himself into the Rice Street Jail yesterday when he heard that he needed to do so. He's done that for 2 years. For that, for 3 years, he drove a truck for Norton Transport and still does that part-time for them as well. He would ask the court to consider a signature bond. He does, well, the state's not asking for a stay away, so I want to address that. The family does still live together. I think they should be in counseling. There was a tragedy in the family. Miss Johnson's daughter, that is to say my client's stepdaughter, was 15 years old and was killed at a park, at a party, and there was gunfire. And they've been going through this tragedy. I think they could stand to have some counseling.
Okay. Is this Miss Johnson on the line with me? No?
No, this is daughter.
Okay.
Oh, yeah, I'm sorry. I had to go out and come back
Okay,
in.
you're fine, Miss Johnson. If you raise your right hand for me, please. Do you swear from testimony you're about to give before this court be the truth,
Yes.
the whole truth, and nothing but the truth? Okay. You're gonna have to put a little bit more light on yourself. Do you have a jacket?
No, oh, yes. I need to put on a jacket. Okay.
Yes,
Hold
ma'am.
on. Oh, shoot. Where is it? Okay. Okay. Is this lighting better?
Yes, ma'am. All right, thank you, ma'am. What would you like to tell the court?
I would just like to say, like, yes, he has still been staying here in the choke. I just wanted them to just, take him away so both of us can get a breather.
Has this happened in the past?
No.
And you're not afraid of him? And you'd like him to return to the household? Okay. All right, thank you for being here this afternoon. Signature bond through pretrial, level 1, 1 day anger awareness, no further violent contact with Ms. Johnson, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Winfrey.
Next comment. Number 12.
So this is Mr. Damon Thomas, is that right? Okay. He's number 1 on the add-on calendar. Good afternoon, Mr. Thomas. You've been charged in case 24 CR 0070 and willful obstruction of a law enforcement officer. Is there a history?
Question, what was the contact for that last case?
No further violent contact.
All right, Thomas 13. Last arrest was in August, misdemeanor, possession of tools for the commission of a crime. That's open, 24 PI 006092. 24 SC 001-522. 2020 DUI conviction.
Thank you. Ms. Huda?
Yes, Your Honor. So on October 10th, 2024, officers from Georgia State Police were near 101 Piedmont Avenue, walks on secured bikes and e-scooters in an attempt to steal some of those items. Officers exited the vehicle, ordered defense, ran. The officer deployed his taser, but it had no consequences. Ultimately, he was apprehended by the Georgia CCTV footage of the defendant attempting to steal an e-scooter valued at approximately $500. Your Honor, this did happen again on October 10th. He pled guilty to the theft, and those were that was the theft of an e-scooter from Georgia Tech University, from Georgia Tech, and stealing or allegedly stealing e-scooters just in the close in time proximity of these incidents. The state would $100 on each, a stay away from the entire Georgia State University campus, and no drugs, alcohol, or weapons.
Do you know if
while
that
out
was a
on
time
bond.
served plea?
It was
Okay.
actually, I believe he's on
Would
probation.
you check to see if
I'll double check
I
that
was
as
the
well.
one to issue that for me?
Your
Thank
Honor, my
you.
client works for
Mr.
his
McClain?
uncle in the home improvement business called Rick's Home Improvement. Rick is his uncle. There's no reason for him not to be able to obey any stay away from any part of town the court wishes, because his address is over there in Stone Mountain. Emphasize that one of the two charges is an attempt rather than the completion that he's charged with, and the other is simply running 2 blocks. So we would like to ask the court to consider a single bond under those circumstances.
Your Honor, I can't, if your signature is legible, Your Honor, I don't believe that you took that plea. That in terms of being able to follow court orders, he was to stay off Georgia Tech's campus, and then 1 week later picked up a new case from going back to Georgia Tech. And so that gives.
Okay. It's going to be a $250 good bond per charge, makes for a total of a $500 good bond. Stay away from the incident location, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Thomas.
Number 3.
Mr. Garcia, good afternoon. You've been charged in case 24 CR 007057Y with following too closely, too fast for conditions, and driving a CMV without a CDL. Is there a history?
Third
Mr.
arrest
Howard?
month. Got October 11th, theft by taking. October 9th, possession of drug-related objects, possession of a Schedule 1, possession of a firearm or knife during a commission. That's all.
Yes,
I go.
Thank you.
Your Honor, this incident took place on October 3rd. Officers responded to 400 southbound on the access road regarding an accident. Police arrived on scene. Police investigated the accident, determined that the defendant was at fault. The defendant was driving another vehicle. The officer determined the defendant was driving too fast for conditions. There was very heavy traffic. Traffic was stopped. The defendant made no attempt to stop and rear-end the vehicle, and so on until 4 vehicles were involved in this accident. The officer also determined that the defendant was following too closely because he did not have adequate time to stop. The officers ran the defendant's license and determined he does not have a valid CDL for the vehicle that he was driving. And given his criminal history, Your Honor, the state's requesting a $1,000 surety bond. Charges: no driving a commercial motor vehicle without proper license, no weapons, drugs, or alcohol while out of bond.
Cook?
I'm sorry, what was the amount of the bond recommended, Your Honor? I'm sorry, Ms. Dessian.
It was a split bond. The state's asking for a $1,000 good bond on the CDL charge and a SOB on the remaining. No driving a commercial vehicle without valid license, no weapons, drugs, or alcohol.
Thank you.
Your Honor, in light of the felony bond, and obviously got bigger fish to fry, obviously we would have no objection to that. If possible, that the CDL bond be a signature bond as well. He has modest income. He works for a towing company off and on, and nothing further.
Right, this could be $1,000 signature bond on each charge, makes it a $3,000 signature bond. It's going to go through the jail. No driving a CMV without a CDL, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Garcia.
Position number 2.
Okay. So I believe that completes the 2 o'clock calendar. Is that correct?
Yes, sir.
Okay, thank you. Ms. Bridgewater, whenever you're ready.
State, what happened with Marlon?
NOD, I believe.
Yeah.
Oh, okay.
Correct. Yeah.
And did we do Ramsey?
Number 11, we did.
Okay, yeah, we did it. Yeah. Holly, you got unmute.
Okay, sorry, I was having problems unmuting it all. Okay, once again, the reset date for the SAP calendar is October 29th. Position number 1 is reset further notice with a $2,000 SOB through the jail. 3 is reset further notice with a total $3,000 SOB through the jail. 4, reset further notice with a $3,000 SOB through pretrial. 5 is going to the SAP calendar with a total $2,000 good bond. 7 is reset further notice with a total $3,000 SOB through pretrial with a cosigner. 8 is reset further notice with a total $5,000 9 is reset further notice with a $2,000 SOB through pretrial. Position 10 is reset further notice as the defendant has been released. 11 is 12 is reset further notice with a total $3,000 SOB through pretrial. 13 is reset further notice with the add-on is going to the SAP calendar with a total $500 good bond. Are there any questions?
What's the
comments,
bond for
or otherwise?
12?
12 was a total $3,000 SOB through pretrial.
And number 4 was per judge.
I believe I said that.
You did not. That's why I'm
Okay,
reminding
well,
you.
I didn't.
I'm
It
just
is
making
per
sure you
judge,
got it.
everybody. Per judge, okay?
I'll be up there to see you in a minute. I got
Oh,
a
please don't.
I got to. I got an amended bond I got to send to the judge for a case from last month.
No problem.
All right.
Are there any others?
I have an unrelated question. Does anyone know what day the SAP calendar goes out for Tuesday?
What day?
Jerome, do you know?
Is it Friday?
It should go out today. Excuse me, tomorrow.
Okay, and who normally sends that out? I'm just asking because Miss Fox on her honeymoon, so I'm in charge of getting that to all the people that need to get it. So I need to make
Mr.
sure I
Gordon.
contact that person and tell them that I'm on the email.
She did let us know who to send the information to.
Okay, cool.
Yana
Thank you.
told
Never
us
mind.
last Thursday at SAP, but it will be Mr. Jordan.
Okay, thank you.
All right, you're welcome.
Anything else? If not, we'll see you all next time. Have a good rest of your day.
Okay, take care, everyone.
Thank you, Judge.
Judge, I see